Good evening, ladies and gentlemen. It's a great pleasure. My name is Professor Paul Craig. It's a great pleasure this evening for me to be giving a warm introduction to the Maccabean lecture for this year, the Maccabean lecture in jurisprudence, which was given by Professor John Baker. John Baker, FBA, which is concerned with our unwritten constitution. Now, many people will already know the prestige and learning of our speaker this evening. It's certainly the case many years ago when I was quite a student myself. Whenever we ever had any problem concerned with legal history, someone always used to say, well, go and see what Baker says about it, but that's bound to be right. And it always was. So without more ado, I'm going to pass over to Sir John, who is going to talk to us tonight about our unwritten constitution. There will be time for questions thereafter. Thank you very much indeed.
Thank you, Paul. It's a great privilege to be invited to deliver this lecture, and an act of amazing rashness on my part to choose this subject. I think it's very probable that when I was invited several years ago, it was expected that I should speak about more remote legal history. If so, I can only apologize. In my defense, I could cite good precedents for legal historians complaining about constitutional dangers, most notably John Selden, whose name would need no commendation to the founders of this lecture. But he lived in an age when history provided live ammunition in defense of the liberty of the subject and the independence of Parliament. That kind of legal history is no longer of any forensic value in this country. And my concerns today are rooted in very recent history and came into focus after the inept announcement by Mr. Blair on the 12th of June 2003 that he had abolished the office of Lord Chancellor, apparently without consulting anyone outside his own circle. And I'm going to confine my remarks to the brief period since then, although there's a good case for regarding the progressive surrender of autonomy to the European Union and the various experiments with inland devolution and local government as beginning a major constitutional revolution well before 2003 and as raising concerns at least as troubling as those on which I shall be concentrating. Now, when I delivered a public lecture in 2004 on the constitutional revolution, as I called it, one of my chief complaints then was that grave changes were occurring almost daily without much public notice being taken. Now, 5 years on, and almost 4 years since I agreed to give this lecture, I can hardly complain of a complete lack of publicity, at least for those sufficiently well informed and with sufficient leisure to search the internet regularly for the appropriate keywords. But I've come to the conclusion that the problems which I tried to identify in 2004 have deepened, and that the revolution to which I then referred is not the same as the constitutional renewal which the government has proudly announced. In fact, there seems to be such a gulf between the public statements of the government and its actions, though one might be forgiven for thinking that the language of renewal is more rhetoric than reality. Some call it spin. Now, it's admittedly difficult in approaching this sort of subject to separate constitutional matters from matters of political judgment and opinion. I'm not sure that ministerial incompetence, arrogance, inefficiency, excessive centralization, or over-regulation can properly be regarded as unconstitutional, except in the sense that it's generally beyond the power of anyone to do much about it. They're certainly not wholly new, but problems with the Constitution do seem to have come to the fore in recent years, chiefly because of perceived changes in the style of government. First, there's the concentration of power in the Prime Minister and his special advisers at the expense of the Cabinet and a professional civil service. It's become fashionable to speak of an increasingly presidential style of government. But this doesn't, of course, mean a constitutional presidency. In our case, it means a new kind of monarchy. Now, the chief difference from ancient monarchy is that our quasi-monarch is indirectly elected, very indirectly in the case of Mr. Brown. But once in power, he is an absolute monarch for a term of years. And the Prime Minister would only have to persuade Parliament to suspend the quinquennial system of election, and he really would be an absolute monarch. I hope that's still unthinkable, but I'm less sure than I was 10 years ago. Depends on the House of Lords, to which I shall come back. Now, there's nothing new in the notion that we have an elective dictatorship. I remember Lord Hailsham coining that term in his lecture in 1976. But it has become a more common figure of speech, as evidenced by over 9,000 hits on Google. 9 times, incidentally, the number I counted in 2004. And without any opportunity for electoral approval or dissent, we have acquired a form of government which appears to operate without reference to traditional advisory mechanisms or public opinion. Proposals of a fundamental nature, and I'm referring to constitutional proposals, often come as a surprise to the outside world because there's been no preceding clamour for them. And I'm not sure the civil service or even the cabinet are always made privy either. And the dismissal of the Lord Chancellor is a classic example of that. No doubt it makes life easier, more efficient for the Prime Minister if he can just turn to his chosen advisers on the sofa for guidance. And since his party commands a majority in the Commons, it must be an irritation, and perhaps seen as inefficient, to have to bother about consultation, precedents, or even Parliament. But there is reason to doubt whether the presidential model is working well even in terms of managerial efficiency, because it places a heavy emotional and physical strain on a Prime Minister if he's to be responsible for every detail in person while trying to appear infallible in public. There is now widespread dissatisfaction with the growing phalanx of special advisers and policy units and the replacement of old-style civil service mandarins with managers who are appointed not to advise independently, but to deliver at all costs. And there is perceived unmerited self-confidence in present-day government about its natural superiority to other institutions and its mission to control them, not the least troubling manifestation of which is the seeming indifference to independent legal advice, an undesirable consequence of which has been regular confrontation with the courts. It could easily have been avoided. Another is the indifference to truth. It's been very harmful to popular confidence in government that civil servants are so often ordered to mislead the public. A different problem is that ministers have come to evaluate their performance in terms of legislative hyperactivity rather than effective results. Success is measured in terms of news headlines, most easily captured by announcing something ostensibly new. New targets, new directives, new quangos, new statutes, new regulations. There are, I'm told, I haven't counted, around 15,000 pages of legislation every year now, and the present government is famously credited with the creation of some 3,000 criminal offences. It's now standard practice to lay bills before Parliament which are little better than outline plans, to be somehow refined as they're pushed through, or all too often after they've been passed. And in their rush to notch up their contributions to the statute book, ministers jostle each other for parliamentary time. Why, we might ask, in the Constitutional Reform and Governance Bill, is the civil service dealt with in the same measure as bits of the royal prerogative, public order, and amendments to the system for appointing judges? Well, the Lord Chancellor told us last year the government couldn't spare enough parliamentary time to take them separately. These are constitutional questions. And this brings us to the far greater problem that we have no proper mechanism for constitutional change. Mr. Straw said in a lecture in February last year that the Constitution exists in hearts and minds and habits. It would have been more accurate to use the past tense. But what he didn't say, of course, is that it can't be appropriate for the settled assumptions which have worked so long by consent to be changed unilaterally by the government whose power they are designed to limit, particularly by the very government responsible for some of the most serious challenges to the rule of law in recent history. And even among supporters of the government, there seems to be no fear that some future administration, perhaps formed by a party reflecting popular frustration with traditional politicians, might abuse the newly increased powers which it will inherit. Short-termists do not comprehend the notion of bad precedents. Now, the creation of a Department of Constitutional Affairs on the 12th of June 2003 was even more shocking than the bungled abolition of the Lord Chancellor. Although it's now been renamed the Ministry of Justice, the original name let the cat out of the bag. Mr. Blair had simply commandeered the Constitution and put it on a par with immigration, defence procurement, or the health service, to be managed on a routine basis as an act of governmental power. And that's still the current policy, despite the change of title. In fact, the offence has been compounded by the establishment this June of a Democratic Renewal Council. Surprising name, since its last recorded use was by a military junta in Thailand. The effect was to transfer responsibility for changing the Constitution from a ministerial department, which was bad enough, to a secret cabinet committee. Yet how many people have heard of this arrangement? The press and the public seem to have become utterly indifferent to the very idea of constitutional propriety. So what is the government up to? According to its own green and white papers, the guiding objective is to rebalance power between Parliament and government, to give Parliament a greater ability to hold government to account, and to surrender or limit powers which in a democracy should not be exercised exclusively by the executive. Well, no one would quarrel with that. In fact, it's exactly what we need. But in practice, it isn't happening. The bill which resulted from the proposals in those papers relates chiefly to war-making and treaty powers and to the management of the civil service. And those are steps in the right direction, but they fall far short of the announced objectives. The treaty provisions are too late to save us from Lisbon. The problem of special advisers is not to be tackled, and the government has even rejected the advice of Lord Wilson that they should be forbidden to recruit, manage or direct regular civil servants. As to prerogative powers, it was already unlikely that a government would embark on armed conflict without some kind of parliamentary approval. The Iraq War actually gave rise to a proper 17th century style debate in the Commons. The problem was misinformation rather than the absence of debate. Truth again. More significant, it seems to me, are the prerogative powers which are still not subject to any scrutiny at all. Good example is the power to restructure government itself by abolishing ministries and setting up others, something the government does without any public explanation or costing, let alone discussion. And the power is chiefly used now not to increase efficiency, but to favour or remove individuals or to secure votes in the Commons. There are now 120 ministers, and 40% of Labour members of Parliament are on the government payroll. And it's exercised with such dizzying frequency that few ordinary people know what departments are called, let alone what they do. Education, for instance, seems to have disappeared somewhere recently. If we try to discern a guiding strategy in the government's statements, we might conclude it was the separation of powers. This is a rather new religion in this country, not much revealed in government scripture before 2004, but it provided a convenient excuse for the bungled attempt to abolish the office of Lord Chancellor, and it has, of course, borne fruit in the removal of appellate jurisdiction from the House of Lords to the Supreme Court. Yet, whatever the merits of rehousing the highest court, no one could seriously suppose that this elaborate gesture, which was not properly planned, has the slightest practical effect in relation to the separation of powers. As a symbolic gesture, which is what it was, it is far outweighed by the reality of less dramatic changes which have placed the court's budget under the control of an ordinary government department, subject to competition with prisons, the probation service, tribunals, constitutional reform, and anything else which might be transferred to it in further reshuffles. a department which will often be appearing as a party before the courts which it runs. And seemingly unconscious of this incongruity, the government announced that this reform would strengthen further the already strong judicial-executive links. So the Supreme Court was an expensive diversionary tactic, drawing attention away from the actual movement in the opposite direction. Real judicial independence is, of course, crucial, but here also there are signs that the government is pulling in the wrong direction. It would have been far better if the final decision on appointments had remained in the hands of an old-style Lord Chancellor with all the traditions of that office, rather than a minister in the centre of the political arena, advised by a body which he appoints himself. And the woolly language of Section 1 of the Constitutional Reform Act, which commendably purports to preserve judicial independence, doesn't apply to the appointment process and is not enforceable in the courts. And all this matters because the government is far from neutral about judges. The Constitutional Reform Bill originally sought to give the government power to redefine merit for the purpose of judicial appointments, and that was a proposal Lord Faulkner was very reluctant to give up. They now want to achieve a similar end by setting targets for the Appointments Commission, perhaps even quotas, which might possibly make sense for lay magistrates, but certainly not for the superior judges who are going to be watching the government. If a judgeship comes to be seen as a mere job, to be distributed like other jobs on a sort of fair basis across a section of the community, then it will become much easier to make political appointments. And ministers have in the past indicated a desire to have confirmation hearings so that they can exercise political influence of the kind we've seen in other countries. However, the chief respect in which the government doesn't really believe in a separation of powers is the relationship between the government and Parliament. As Lord Scarman said in 1989, we have achieved the total union of executive and legislative power which Blackstone foresaw would be productive of tyranny. Not that the lack of separation itself is tyrannical. It's been an accepted feature of the Constitution for at least a century that the government may pass any legislation it wishes, provided it's not too shocking. But unfortunately, that principle applies whether or not the legislation is properly thought out, whether or not it rides roughshod over long acknowledged principles, whether or not there's adequate time for scrutiny or consultation, whether or not it's generally acceptable to the electorate or even to their elected representatives on the back benches. And this inability of Parliament to hold the government to account was actually recognised as a problem in the governance of Britain White Paper. But the point that I'm going to be trying to make is that the government haven't really shown much practical interest in finding a remedy. The principal check is the House of Lords, to which I'll return. Some apologists have argued that the Commons has actually become more effective in recent years, in that backbenchers are more inclined to revolt than they were 50 years ago. But contrary evidence, I would suggest, is provided by the infamous story of Clause 11 of the Asylum and Immigration Bill in 2003, which, as you may remember, provided that there should be no appeal or judicial review in respect of decisions by the new tribunal, whether for want of jurisdiction, error of law, or breach of natural justice. And this clause was opposed by Lord Irvine when Lord Chancellor, because it was contrary to the tradition of the rule of law, and some suspect that his removal from office was related to that disagreement. It was the subject of strong attack by Professor Bogdanor, who said it was a constitutional outrage and almost unprecedented in peacetime. It was attacked publicly by the then Lord Chief Justice, Lord Wolfe, in a lecture in Cambridge, after he and other members of the judiciary had advised that the clause was fundamentally in conflict with the rule of law, and also by another former Lord Chancellor, Lord Mackay, who said it was obnoxious. It was condemned by the Constitutional Affairs Committee of the House of Commons as unprecedented. And alarmingly, and this is my point, none of this had any effect. The bill passed the Commons after a debate in which no one but a junior minister spoke in favour. He'd been sent to do the deed, and 35 Labour MPs were strong enough to vote against, but that's not enough. and it was only the threat by Lord Irvine himself to speak against it in the House of Lords which forced his successor to back down. Now, I should make it clear the controversy wasn't about asylum or immigration policy. Perfectly legitimate to argue that the policy should be more ferocious or even made to work, and that the vast funds spent on immigration judges diverted to public welfare. But the dispute was about the rule of law. And although the immediate outcome was satisfactory, it was only a temporary respite. There have been several attempts in the last few years to confer arbitrary power on the government, not only in emergencies but in everyday situations. And I pass over the terrorism acts because there's been a lot written about those anyway. But not limited to terrorism was the Civil Contingencies Act of 2004, a project modelled on the Wartime Defence of the Realm Acts, but of unprecedented scope, almost unprecedented scope in peacetime. Amongst other things, the bill would have empowered a Secretary of State to take emergency powers to do anything that could be done by Act of Parliament. In other words, anything, including the requisitioning and destruction of property without compensation, the prohibition of movement and assemblies, creating criminal offences and establishing ad hoc criminal tribunals, and there were provisions for ministers to disapply sections of the Act itself so they could rewrite it as well if they found it wasn't wide enough. Now, much of that was watered down before it became law, but it was a serious warning of the sort of powers the government would like to possess. The government even declined a request to insert a sunset clause, so emergency is no longer a finite event. And it declined to exempt legislation of major constitutional importance from the disapplication clause. So it's not as if it wasn't asked to change those things. Now, I'm quite prepared to accept that extreme measures would be necessary to cope with, say, a nuclear attack on London. That's obvious. But neither the bill nor the Act as passed was confined to nuclear attacks or anything as serious as that. The Act as passed applies to any emergency which is defined as an event or situation which threatens serious damage to human welfare, environment, or national security. And the government has already shown that it believes that that extends, for instance, to economic emergencies such as bank failures, because it was used to deal with the Icelandic bank. It's not confined to terrorist acts, but it includes any loss of life, illness, homelessness, damage to property or human welfare, disruption of communications and transport. So you could put Cumbria under military law, probably. And as if that definition wasn't wide enough, the bill would have enabled a minister to extend it by statutory instrument. Now, it's become fashionable to speak of clauses like that as Henry VIII clauses, though in fact they have little or nothing to do with the Tudor period. Henry VIII couldn't get away with anything like that. He tried it, and the Commons wouldn't have it. The first example of a Henry VIII clause occurs in the Local Government Act of 1888, and such clauses were still sufficiently uncommon in 1929 to provoke the then Lord Chief Justice famously to warn of the new despotism which they threatened. It is only in very recent times that they've been widened to empower ministers to rewrite parliamentary legislation as they think fit. A disturbing example of that occurred in 2006, when the government attempted, in the Legislative and Regulatory Reform Bill, to sideline Parliament quite independently of any emergency. The government wanted to give ministers the power to amend, repeal or replace any Act of Parliament simply by making an order. And this was said to be potentially helpful in reducing red tape. That sounded wonderful. We all want to reduce red tape. The press and the opposition were taken in for a time, and they didn't notice the small print. Actually, it wasn't that small. And the government almost got away with it. But the sheer enormity of the proposition was drawn to public attention by a letter written to the Times on the 16th of February 2006 by 6 Cambridge law professors. The reaction was interesting. Some of the government's defenders thought the offending clause was just a result of overzealous draftsmanship. It really was primarily intended to reduce red tape. It was nothing of the kind. If it had been, the government would have accepted amendments. Instead, they fought hard to defend the indefensible and refused to insert safeguards for fundamental liberties. The letter writers had the honour of being denounced by Lord Lipsey in the House of Lords as 6 silly professors who were not living in the real world. And yet, this wasn't even a Henry VIII clause as understood in 1929. It was more of an enabling law, an Ermächtigungsgesetz of the 1933 variety. The House of Lords Constitution Committee woke up to what was happening and said the bill would markedly alter the respective roles of Minister and Parliament. Even then, the government wanted to push ahead, offering the assurance that it wouldn't abuse the power. And that, of course, is the moment to worry. When a government says, trust us, we don't need a constitution anymore, we're so right that we'll never do anything wrong. That was exactly what Adolf Hitler told the Reichstag on the 23rd of March 1933. Perhaps I quote him in translation. The government will use these powers only insofar as they are essential for carrying out vitally necessary measures. The number of cases in which a necessity exists for having recourse to such a law is very limited. Well, I don't suggest, of course, that constitutions can prevent tyranny, but they can facilitate it. Hitler found the Enabling Act most satisfactory to his purposes and even took the trouble to have it renewed twice when it expired. Well, in 2006 we were saved by the threat that the House of Lords would scupper the bill. Notably, it was once again the Lords, not the Commons, which served to protect Parliament, and that, I suppose, was another nail in their coffin. The underlying lesson was not absorbed in the corridors of power, and things haven't changed under Mr. Brown and Mr. Straw. For example, Clause 55 of the present Constitutional Reform and Governance Bill, if I may not be up to date on this, but I think this is right, provides that a minister may, by statutory instrument, make any provision that he considers appropriate in consequence of the Act, and that such an order may amend, repeal, or revoke any provision made by or under an Act. In other words, any Act. So ministers now seek the power to rewrite even constitutional statutes without consulting Parliament. These clauses are now installed in government computers, and they're given a little stretch each time they're dropped into place. I won't bore you with further examples, but there are plenty of examples. And then there are the more concealed varieties, such as that under which the Home Secretary recently sought to confer sweeping powers on local authorities under the Proceeds of Crime Act. Now, at best, these clauses acknowledge that statutes are prepared, which are prepared with haste, need constant rewriting. But it's a high price to pay for sloppiness, since it prevents proper scrutiny and it avoids professional draftsmanship. Even where powers are subjected to the affirmative resolution procedure, there's no possibility of amendment, and the time for debate is limited. And it's not an acceptable solution to say, oh, well, the High Court can sort it out in judicial review, because only those who can afford litigation in the High Court will be able to find out which orders are valid and which aren't. At any rate, we now know what the government means by rebalancing power between the executive and Parliament. There's enough similar fact evidence to prove a deliberate programme of shifting power towards the executive, complete opposite of what they've said in their green and white papers. Now, some of these problems have no legal solution under our present constitution. They were avoided in the past by those conventions which existed in hearts and minds and habits. But since those no longer count for anything, we've all been reflecting on the desirability of a written constitution. The government is against this, so there's been another diversionary tactic in the form of proposals for a new Bill of Rights, announced in a press leak in March. Now, the effect of putting a range of civil and political rights into a new statute would seemingly be to create a parallel and possibly conflicting human rights regime with no obvious purpose, unless it is simply a new version of the Human Rights Act. It is now proposed to insert responsibilities as well, but since these are already part of the law, their inclusion in a separate document in different language has no obvious constitutional significance, but it could cause considerable legal confusion. More than confusion is threatened by the proposal to add a new range of economic and social rights. These are admittedly found in some other constitutions, but they're not so much legal rights as political aspirations. Fundamental rights are those which no government can lawfully take away, based on some higher law. whereas these new rights are not yet in existence, but are goals which the government hopes to reach someday when it can afford to. Now, there's no harm in announcing political goals, especially when they're essentially laudable, but it has nothing to do with constitutional change. It belongs to the same category of law reform as last week's announced fiscal responsibility bill, which would halve the national deficit by legislative magic, just as one might reduce the crime rate by abolishing crimes. Misusing the language of rights, however, is potentially dangerous, because even though the rights would not, as I understand it, be directly justiciable, judges would be able to take account of them in assessing, I quote, the reasonableness of the measures taken to achieve their progressive realization. Now that would herald a new kind of law, empowering the judges to exercise an essentially non-legal function of unknown scope. And I would submit that if they are to be given such a broad new role, then it needs much more public debate and shouldn't be just slipped into being unnoticed beneath the cloak of vague aspirational rights to which, as abstract propositions, we would no doubt all assent. I would suggest the principal question is not whether we should have another Bill of Rights, but whether we should have a true written constitution with judicial review of legislation to ensure compliance. That, I suppose, is a purely academic question in Britain, because no government is likely to agree to confer such a power on the judges, and the present Prime Minister has ruled it out as undemocratic. But there is another way in which it could happen. Lord Millett argued on the wireless in April 2004 that introducing a separation of powers would inevitably, if unintentionally, hasten the end of parliamentary sovereignty. And similar ideas have been mooted by other senior judges. If the government can abandon the conventions of an unwritten constitution, then why not, in a suitable case, the judges? Sovereignty of Parliament, it is argued, is no more than another convention. And judicial review in the United States came about through judicial decision. So that could be the next stage in our creeping revolution, 400 years after Dr. Bonham's case. But it would be a desperate and unwelcome last resort, rather than a satisfactory solution, because the judges would be enforcing an unwritten constitution of uncertain scope. Until the last few years, I myself was wholly averse to the idea of a written constitution with the Supreme Court having the power of judicial review, because it would turn unelected judges into legislators. The problem isn't merely that judges are unelected, and I certainly wouldn't recommend electing judges as a solution to that problem, but that the judicial role is different from that of a policymaker responsible for raising and spending revenue. The case for increasing the power of the judges is that they have tenure, which gives them independence, and that they're trained to pick apart arguments in an informed and dispassionate way. But courts are not best suited to decide on the allocation of finite public resources, especially if the questions are coming before them in actions inter partes in which other claims on those resources are not represented. The courts will think in absolute terms. They're not apprised of the whole economic picture, and they're not politically answerable for the consequences of their decisions. But despite those misgivings, we have to face the question, now that our unwritten constitution has been unravelled, whether judicial review might not be the lesser of two evils. We wouldn't have to follow the American model, on which no one is very keen. There's much to be said for a weaker model, such as the Canadian, under which the highest court can annul legislation, but subject to a power which is very little used in reality for the legislature to reinstate the legislation non obstante for a limited period. And we have a weaker still model ourselves with the human rights regime. But I would suggest that the key to an acceptable model, if we are going to do it, is that it shouldn't empower or allow judges to second-guess the legislature on issues of policy requiring taxation or coercion. Judicial review of legislation should ideally operate more like judicial review of administrative action. That is, it should inquire whether the legislature has acted consistently and fairly, has taken proper account of relevant factors, hasn't taken improper account of irrelevant factors, but it shouldn't substitute the judge's decision on the merits for that of the decision maker. There's already a wide perception, right or wrong, that the courts are inclined to overuse powers of review and to take political decisions themselves. And we need a great deal more public reflection on how to define the proper judicial function, how to draw the line between fundamental law, which the courts will uphold, and politics. And it's far from easy or obvious. I mean, to whom, for instance, does it belong to define life and death, or marriage, or a person's gender? If you have a constitution guaranteeing a right to life, then that seems to empower the judges to decide what life is. And it can mean different things to different people, and it's a very fraught issue in the United States. But if in a plural society we no longer defer to Christian canon law, it ceases to be very clear whether such a question is soluble purely by legal reasoning. And without first achieving some sort of consensus on the ambit of the judicial role, I would suggest that it would be premature to embark on a written constitution with judicial review. It may, in any case, be questioned whether a written constitution would be the best way in practice to solve the kind of constitutional problems which I've outlined. Human rights are comparatively easy. We're doing that. We've got a written code of human rights. It's not entrenched. There are already moves to amend it, and some would argue that it's better that way. Human rights aren't, the definition of human rights is not something you can get right all in one go. The principal case for entrenchment is that it might make it possible for the Supreme Court to reject European legislation which contravened English principles of justice, as can happen in some other countries in Europe. It might even go beyond universal human rights, which were, of course, invented in England. I think the Declaration of Human Rights is said to have been drafted in chambers in Lincoln's Inn. It might even include other common law rights which the European powers would take away, such as the right to rescind contracts of breach of condition. But that's one kind of constitutional provision. But what about the structure and mechanics of government? Much more difficult. It would be virtually impossible to codify all the present conventions of the British Constitution, especially those which relate to political parties or the cabinet, even if it could be decided which of them still exist. And this is partly because they operate more like equity or fictions than rules of law. For instance, the mind boggles at any attempt to codify the present procedures for producing a prime minister, covering every eventuality. So attempting to do that will probably require changes rather than just codifying the principles as they are. Entrenched legislation could, I suppose, tackle some of the specific problems I've mentioned, but to that end, there will be no necessity to set the whole Constitution in stone, an exercise which might result in too much rigidity and prolixity. And a line would have to be drawn between form and substance. Would the electoral system, for instance, have to be enshrined in the Constitution, or is that something which you can change from time to time after debate? But in choosing between those models, we're brought back to the absence of any proper machinery for going about it. It certainly ought not to be left to the Democratic Renewal Council. A better place to start a true constitutional renewal might be the House of Commons itself, since prevention is better than cure. The use of select committees has proved to be one of the most admirable reforms of the last 30 years. And it's only a shame that the wisdom produced by the committees is so difficult for outsiders to access. It is, I believe, now generally accepted that they need to be given more clout, with chairmen elected by secret ballot and with independence from the whips. We might learn something from Scotland, where I believe they have much more power than here. Another desirable change, which seems to be generally agreed, is that the government should lose its absolute control over the management of business in the Commons. And the Commons ought to take back its audit functions by discussing estimates and controlling supply. Some way of capping the volume of legislation is also desperately needed. Heaven knows how you do it, but it's needed. Helped perhaps by a more liberal use of the sunset clause, a true Henry VIII clause, which was used quite a lot in his time, or by requiring a periodic review of the effectiveness of new measures. That might sharpen ministers' attention to what they're doing. But none of that forms part of the government's renewal policy. For the present, the most effective check on legislation is the House of Lords. Effective because its members have tenure and are free to ignore the party whip. And although Labour peers now constitute the largest party in the House, over 350 living peers are Blair nominees, peers have on several hundred occasions in the past decade followed their consciences or good sense to thwart the Labour government in a way that members of the Commons would consider politically or financially risky. There is, therefore, a separation of powers here, even if the powers were severely reduced in 1911. By a curious reversal of history, the House of Lords has become the principal defender of constitutional liberties, and arguably the more significant legislative chamber, albeit at the cost of endangering its own existence. Having been made more politically correct by the removal of most of the hereditary element in 1999, it has, of course, noticeably gained confidence. But the sorry consequence is that, in government thinking, it must be made less politically effective. And I submit that the future of the Lords is, at the moment, the paramount constitutional concern, because without an effective, independent upper chamber, the entire High Court of Parliament is in danger of becoming fossilised, a magnificent heritage site with no function. Now, on the 7th of March 2007, the Commons voted to ignore the conclusions of the Royal Commission of 2000 on the House of Lords and press for an elected, or at least 80% elected, House of Senators, composed chiefly of full-time politicians. A few days later, the Lords voted by 361 to 121 in favour of a 100% appointed chamber. Then Mr. Straw announced his determination to push through the wishes of the Commons, apparently in the belief that this is the course required in a democracy. Now, even if such a course isn't actually illegal, and there's a case for saying that it is, this is another disturbing example of the government's inability or unwillingness to understand constitutional proprieties. How can it be the business of the Commons to tamper with the only effective control on their power? It would never happen in a country with a written constitution. That is, most other countries. But alas, our constitution provides no specific guidance to those who choose to distort it. The merits were fully considered by the Royal Commission 10 years ago and seem then to fall on the side of an appointed or largely appointed House. Those of us outside the world of politics can see that popular elections for the entire House of Lords, even if not tied to general elections for the Commons, are very likely to give both houses a similar political constitute make-up and almost certain to make the Lords a clone of the Commons in a more insidious way. The conditions of appointment would only attract those who are already politicians or are committed to being full-time politicians, many of whom would doubtless find a salaried seat in the Lords much more congenial than the tedious constituency work expected of a Member of Parliament these days. And the important element of membership with experience of the real world would be largely squeezed out, as would the present social diversity of peers, which is far more impressive than that of the Commons. The House would be enslaved by party politics, and its valuable function of taking the wider view endangered. Why is this thought necessary or desirable? There is no democratic reason why all the Lords should be elected. Granted that an elected government is entitled to have its policies passed into legislation, it doesn't follow that the product should be rough or unworkable or unconstitutional, and it's in everyone's interest that problems be ironed out before a bill is passed rather than pursued in the courts afterwards. And the sort of House of Lords that we have, leaving aside the question of membership, would seem preferable. Now, unquestionably, there are grave objections to the present process of nomination to the Lords, which has all too often been used to ennoble second-rate or unseated politicians, kind of people who take cash for questions, or even a speaker who's been effectively ejected from office. Setting up an independent appointments committee would not be without difficulty, but in my submission, any sensible system of appointment would seem preferable to general election. Quite apart from all the questions that would arise about legitimacy, if the House of Lords appears to have the same democratic legitimacy as the Commons, then why should it defer to the Commons, and all those questions which have been much debated? Well, I've only been able to touch on a few of the myriad questions which have been stirred up by the constitutional activities of the last 7 years, and I'm afraid I've had to do it in a very superficial way. But a general observation which I would like to underline before I end is that they are interrelated. Most important of all, the question whether we need a written constitution and more judicial review, more active judges, is directly and necessarily connected with what happens to the House of Lords and the political constitution. Because if there is no control on the executive in Parliament, then it has to be the judges, and no one else can do it. There's very little indication in the government's approach of any coherent strategic vision. Indeed, much of the recent activity seems to have been a result of short-term expediency. Abolish the office of Lord Chancellor as a clever way of removing Lord Irvine. Weaken the House of Lords because it's proved vexatious. Scatter power to change law clauses in bills to save the bother of careful draftsmanship. Typical of this approach was the Parliamentary Standards Bill, rushed through Parliament in July to appease journalists on the expenses front, with no awareness of the wider constitutional implications which were only pointed out in the nick of time. So if there is to be constitutional reform, and there seems to be no way of stopping it, there ought to be some new mechanism, independent of government and of the House of Commons, to consider it as a connected whole. The House of Commons Justice Committee, in its report of the 21st of July, proposed a constitutional convention. And that might well be the best solution, however problematic its own constitution and authority might be. But it shouldn't be expected to deliver results within a short timetable, like before the next election or anything as daft as that. The mad rush of the last 7 years has proved to be quite the wrong approach. Constitutions must rest on a broad consensus, and we seem to be a very long way from having any kind of consensus as to what is required. No independent convention will reach agreement at its first meetings. It may well be, as Professor Bogdanor has suggested, that it would be advisable to have a Royal Commission first, before even proceeding to the convention stage, to take evidence and to sort out what the questions are. I would suggest that a convention would have to resist the temptation to redesign the Constitution from scratch in minute detail, because since the reality is that whatever is proposed would need government support, the effect would be to offer dozens of proposals from which ministers could pick and choose the easy ones while shelving the awkward ones. And it should also be borne in mind that unduly radical changes would divide moderate opinion and prevent consensus from being reached. So the best way ahead would be to try to find some general consensus on the big questions, but in a related, overall related way. And in connection with consensus, I would end with the observation that no sensible progress can be made without a greater public awareness of constitutional matters and involvement in the debate. The hearts and minds must be re-engaged somehow. Politicians, I imagine, suppose that there isn't much doorstep interest in questions which may seem rather abstract or academic, and therefore no political profit to be gained from pursuing them. Mr. Blair famously tried to put down Mr. Hague in the House of Commons in 2000 by saying, "I don't know whether people in his pubs and clubs are talking about pre-legislative scrutiny, but they're not in mine. These are good issues for academics and constitutional experts, but they're not the big issues which Parliament should debate." Well, I would suggest that that may be a misjudgment, because when I've spoken on this issue, as I have before, I've found a great deal of interest amongst non-lawyers and lawyers in these matters. But the absence of basic awareness has suited the government very well, and it has unfortunately been reflected in the press. which, despite the acuity of many individual journalists, some of whom are here this evening, seems to feed the public appetite for personal scandals and no longer seriously reports parliamentary debates, let alone select committee reports. When a Lord Chancellor's wallpaper can attract as much media attention as the abolition of his office, it's hardly surprising that the sordid but undoubtedly titillating business of outrageous expenses claims should fill more column yards than the far more important constitutional questions which are currently hanging over us. And yet busy citizens, such as lawyers, have no time to delve into the recesses of the internet on a regular basis to find out what's going on. And so the response to white papers has been quantitatively thin, and the bar has been largely silent. It isn't that they're not interested. It's just that most people simply don't know enough in detail about what's happening, and it's all happening far too fast. It's also, I would suggest, the fault of our educational system. What can the long struggle between Crown and Parliament, the petition of right, habeas corpus, and all those things which were in the bloodstream of Selden's contemporaries mean to a generation which has studied no history before 1914? Well, it may be too late to undo the present revolution, which has happened so fast we've all been left gawping. And there are optimists who are pleased by that. There are always those who like to see institutions shaken up regardless of the consequences. My own chief concern is not with change as such. Historians are often very keen on change. It's their lifeblood. Though I may despair at what has been thrown away so casually and unthinkingly, but my concern is with the dismal reflection that we no longer have a constitution in the sense of a set of conventions and practices which keep the government in check and which, though flexible, can be overhauled only by general consensus and after careful thought. The consensus of the last century or more has ended, and the government has stormed into the void, constantly tinkering with constitutional arrangements as a routine exercise of power and without much regard to the consequences. Now, I have no doubt that some people will think me a silly professor or an alarmist to voice such a complaint. Life still goes on more or less as normal. You and I are still free to air our views in public. I brought my toothbrush in case I end up in the Tower of London after this lecture, but we don't have friends who've been incarcerated. Selden, of course, was sent to the Tower, but I don't think I will be. But constitutional slippage is highly dangerous because when power is allowed to become completely unchecked and unbalanced, then even if it starts under a regime which you approve of, it can very soon slip into something else. And I would suggest that the lessons of history are alarming.
John, that was terrific. It has confirmed my long-held belief that beneath every lawyer's skin there's a public lawyer waiting to get out to talk about the grand issues of the day, and you've certainly given us much food for thought. And fortuitous that it may be, the timing of this lecture, as many people will know, coincided with the publication today of the report suggesting a point that John alluded to, that indeed backbenchers and select committees should take far more control over the pattern of business and appointments within the House of Commons. So we'll have to wait and see whether those suggestions fall on deaf ears or not. In any event, we have time for questions, and let me start. Yes.
Yes, thank you, Professor. You had a great many very interesting things to say, but you didn't refer to what seemed to me to be fundamental issues, basically the vote, the way that we elect Parliament, and what's often referred to as the democratic deficit within the European Union. I wonder if you'd like to say something about those?
Well, thank you. I'm not a constitutional expert, I should say. I'm a legal historian, really, and I'm looking at this as a concerned lawyer, rather than someone who's made a detailed study of voting systems. One could devote a whole session to different voting systems and the results which they might produce, and whether it would be better to have hung parliaments and massive majorities and so forth. I don't think I can really contribute anything new on that subject today. It's been much debated. But it raises the same questions that I was talking about how do you go about it? Under our system, it's the government in power who decides what's going to happen. And on the whole, the present system suits the government who managed to be elected. So I think we shall wait and see. But there is a lot of discussion on that issue, so it's not something that's been overlooked. Europe, of course, is another question that I have deliberately avoided, because clearly there are even worse problems there of unaccountability than those which I've mentioned. But I'm not a European lawyer. It's better to avoid them.
Okay.
Can I ask if this fascinating lecture is going to be published, because it tackles problems which must come to fruition in the course of the next 5 or 10 years when we hope to have a different government?
Yes, it will be published.
I very suggest is a copy of this excellent lecture going to be given to every single MP in this country, because it seems to me a lot depends on the quality of the MP sitting in the House, upper and lower house. And you're quite right, the speaker who now is elevated into the House of Lords. So I would think that is a very important, would be very important.
Well, that's very kind of you. I suspect, with deference to members of Parliament, some of whom are here, they're well aware of most of these issues, and more so than those outside Parliament.
Gentleman at the back.
I, in 1977, was successful in defeating the Attorney General on the very simple principle of be you never so high, the law is above it. I've since tried twice more against various members of the government, including 2 prime ministers, and I have failed in the Court of Appeal on both the Nice Treaty and the Lisbon Treaty, because it was felt by the learned judges that we couldn't go too soon and we couldn't go too late, so they had a perfect excuse not to find in my favor. The point I would like to make, sir, your fascinating lecture, is that I believe that we're far further down the road than many people realize, and that a lot of what you've been saying this evening is entirely premeditated by a thoroughly corrupt and evil set of people who are in the pay of the European Union particularly, and are determined to drag us down, and we've allowed this to happen. And my question is, you say that we don't have a written constitution, but how can we possibly have amassed so much legislation and statute of constitutional nature over the last 800 years without writing any of it down? And I would like to know why you consider the Declaration of Rights, the Bill of Rights, the Magna Carta, the Coronation Oath Act, etc., are not worthy of inclusion as part of our defences against this evil.
Well, perhaps they are. They are constitutional documents, certainly. But as you rightly say, our courts at the moment are not willing to place the common law above statute. But there have been hints that if things get really bad, they might just reconsider. I recently signed a legal historian's amicus brief to the United States Supreme Court on behalf of some of the Guantanamo Bay detainees. And the interesting thing is that in the United States, those historical arguments actually sway the court. They really count to something. And there are English precedents which the courts here would not listen to. If Parliament said habeas corpus is not available, that's that, because of sovereignty of Parliament. But there are hints that, as I mentioned, that if something isn't done by Parliament itself, the courts might just seize the power. And of course there's been speculation in the press that the Supreme Court, although in form it's just the House of Lords in another name, there might be some psychological backing for them taking on a new role in the future.
Other questions?
Why is it, do you think, that an executive would take so many powers to itself, safe or in the knowledge that it's going to bequeath these to its opponents when they get into power? Might it just be that it's just that they've got their business done and that's all they care about?
Well, that's what I was saying. Yes, I do find it quite remarkable, because it seems to me that the way the Constitution has held together for most of my lifetime was this notion that you weren't going to be in power forever. And if you push things too far, that would be a precedent which the other lot might take advantage of in the future. And there was a tension between the two. It's short-termism, isn't it? I think government is only thinking about tomorrow's newspaper headlines, let alone next year.
I've often wondered, why do you no longer hear of the use of royal commissions? You mentioned that there should be one for this matter, but I mean, for years now I've never heard of a royal commission.
No, well, of course, they're famously put on shelves and not taken much notice of, as the case of the Royal Commission on the House of Lords, which was one of the last constitutional inquiries. It has traditionally been a way of diverting matters away from government, let someone else look at it, and then we'll just put it on in the library. I can only speculate as to why we haven't had them recently, but so many of the things that I've been mentioning have been announced as government decisions, and then there's a so-called consultation process, instead of the old way, which was that you inquired into matters first, found out what the problem was, collected evidence, and then made a decision in the light of that. Nowadays, we seem to have on-the-hoof decisions, and then you try to set up machinery to support what you've done. It means the consultation process is meaningless. Often there's not very much time, people don't hear about it, the press don't mention that there's such an inquiry going on, so nobody bothers to respond. Even if they do, the government takes no notice, because it's already announced what its decision is, and it can't be seen to back down, because that's thought to be politically weak. And so you don't get any discussion. And I don't think royal commissions fit into that pattern. That's the old way of doing things.
Could you comment on whether you think there might be a risk that if the judiciary, who are already starting to play a bit of a political role, faute de mieux, were to take a more prominent role, they may end up attracting the same sort of contempt that politicians attract?
Yes, I do. And that's why I've always been against a written constitution until now. But it's a matter of choosing between evils. I don't think we can go back to the old system. It's gone. And I think it's a mistake to assume that because our present judges are highly regarded and splendid lawyers, that they're always going to be the same in the future, because if we give them a greater political role, then of course the pressure to appoint politically minded judges will be much stronger. And we may end up with a situation like the United States, where decisions turn on single vote and everyone's waiting for the next judge to die, and they hang on until they're in their 90s because they don't want to create a vacancy and all that sort of thing. Do we really want that? Yeah. Perhaps we do. It might be better than the alternative.
Question? Yes, person at the back.
The Charter 88 Society holds opinion polls from opinion surveys from time to time, which show that the majority of the public, not necessarily always an overwhelming majority, but a solid majority of the public is in favour of all the sort of liberal reforms that you mentioned.
That's not a question.
Okay. Thank you. Thank you. You made an interesting point, which I hope I picked up on correctly, about almost the dissipation of education as a focal point. And yet the importance that you lay on education as a means by which we can look at these proprietary inclusions of important matters that are going through. What would be your recommendation in terms of increasing our awareness from a relatively early age of the importance of an interest in these matters Because surely if we are to change or influence the importance of our understanding, it must happen early on in education. And I'd be interested just in your views as to what you consider to be perhaps the idealistic situation of its inclusion in education from an early age, and perhaps what that early age should be.
Well, I don't claim any profound knowledge of education. My sense is that we've suffered too much from educational experts anyway, but my gut feeling is that it would be helpful if schools just taught a bit of English history before the First World War. And recently the Faculty of History at Cambridge did a review, and they discovered that the majority of students coming to read history at Cambridge, these are people who actually want to be historians, have never done anything before 1914. Which is very interesting, of course. I understand why teachers like to teach Hitler and all that. It's wonderful. You've got all the illustrations and ghastly facts and so forth, but it doesn't solve this sort of problem.
Following the last question, and very pertinent to it, the Telegraph published a leading letter from me recently to point out the uselessness of present teaching of history in our schools, concerned with courses of one sort or another on Tudor shoes, dress under the Stuarts, Victorian walking sticks, etc., when what is needed badly is the sort of course that I had when I was an undergraduate at Oxford, that is to say, a grounding in English constitutional history, especially if it's of a medieval character.
Again, I don't think that requires an answer. I've never tried to teach children, and so I don't know how easy it is to get them interested in constitutional issues. But if there is some way of doing it, it would be well worth considering.
What do you, in your opinion, to whom does a country belong?
Well, I don't think it belongs to anyone, really. The concept of ownership doesn't really work, I don't think, in constitutional terms, but it is a constituted of all the people. Not quite the same as ownership.
I have to answer this question here. The country belongs to the people. And I know I speak with a strange accent, but that's something that was drilled into me from the day of conception,
yes,
is that the country belongs to the people, and the government is merely a reflection of the way the people wish it to be.
Yes, well, of course that's right. The trouble with that is that the present government was elected by the people, in a way.
I think this gentleman down here has been waiting.
Professor Baker, could I ask you what you understand by public consultation? Because apart from voting in elections, I've never been asked my opinion on anything.
No, you have to keep glued to the internet, and if you happen to spot that there's a green paper going out, you can write in. But it's quite difficult to find out because the press don't tell you. And you need to know which sites to look at. So that's the sort of consultation. I don't regard that as consultation at all. And it's not meant to be. If it actually produced a firm response, the government would be very worried, I suspect.
We've still got a lot of questions. The lady back there.
First of all, thank you very much for your analysis, because I find it very helpful to have the perspective alongside what I've been working on. If I can possibly summarize where I see the comparison of that work, if we were to take a game theoretic approach to modeling constitution, or possibly remodeling constitution, we can describe it as a pack of cards. And a pack of cards has 4 houses. So what you have described is 2 houses out of those 4. The third house would be the house of the householder, i.e. the taxpayer. And the 4th house would be the international house. So we can compare our constitution with those of, for example, the constitution of the Antarctic governance structure that is now informing the Arctic Council and the governance structures relating to that. So there are very modern forms of constitution and constitution modelling and formation that we can refer to and will be held accountable against as we speak.
Thank you. You must give evidence to the Royal Commission when it's appointed.
Gentleman back.
If vigilance is important in protecting our Constitution, but our Constitution has never been fully codified, how are we to know what is a matter of constitutional innovation and what is not?
Well, that's a very good question, and that's where one would have hoped the press could help, because they're wonderful when they get their teeth into something. And they've shown with cash for questions and expenses and so forth, they really go after issues and send detectives out. But if they could somehow be made interested in these questions, I think they could achieve wonders in informing the public. But as yet, it hasn't happened.
I think Tony Bradley was waiting.
Well, having had the privilege of being an advisor to the House of Lords Committee on the Constitution for 3 years and dealing particularly with the constitutional implications of legislation, I'm very grateful to our lecturer for having drawn attention to the problems that our sovereignty of Parliament presents, in that any change, any aspect of our arrangements can be changed by Parliament. And one aspect that our lecturer didn't mention, a recent report since my time of the Committee on the Constitution, was drawing attention to the dangers of fast-track legislation, which relate to the practice of the government proposing a bill, allowing a few hours for the Commons to deal with it, and then passing it to the House of Lords and expecting it to do the same. Now, I have a question. My admiration, I think, included for Sir John's lecture the timescale which he chose, which was the last 5 years. And it occurs to me that if one were attempting an overall assessment of the Labour years, one would have to include devolution, the Human Rights Act, and freedom of information. And I don't know whether Sir John might agree that possibly one of the reasons for the success of those 3 immensely valuable constitutional reforms was the fact that they were preceded by a Liberal Democrat stroke Labour programme which went into the 1997 general election. And that was prepared in case Labour did not have a working majority in 1997. But I think the element of a bipartisan contribution and the discussions that went on before the 1997 may have been a real element in the success of those reforms.
Thank you very much. It's a very valuable contribution.
We've got time for a couple more. Here at the back.
I just wondered whether you thought the developments in our constitutional system was less to do with ignorance and more to do with indifference.
Well, that's a matter of political judgment, isn't it? I can't know what goes on in the minds of Mr. Blair and Mr. Brown and so on. But some of the evidence I presented suggests quite deliberate policy, because if you're saying, oh, this is just careless draftsmanship or we hadn't thought about it, then you might amend things when it pointed out to you that there are much wider implications, instead of fighting tooth and nail. And it does seem to me that there is a fairly clear evidence of deliberate grasping of power. We come back to the question of, I simply don't understand why. Why do they think that that isn't going to cause trouble when they're out of office?
Given the problems like this caused by Labour's large majority, to what extent do you think this problem is caused by the first-past-the-post system?
Well, that's back to the voting system again. I mean, of course large majorities are due to first-past-the-post system. But the question is whether, if the alternative produced a hung parliament, whether that would work better. Some people think it would, that coalitions would be better. Some people have argued that coalitions wouldn't be better. It's a matter of political opinion, I think, that one. Can't answer.
Why is it that the opposition parties, since 1997, have not concerned themselves more with these issues? The Conservative Party has been lamentably weak in opposing the measures, and the Liberal Democrats have very often thrown their hat in the air and say woo-hoo behind the government's proposals. Now, this is in marked distinction with what has happened in the past, For example, between 1945 and 51, the Conservative Party in opposition opposed the government on a number of measures, including that, and some of the speeches were made by the leader of the opposition, Mr. Churchill, on relatively small measures like the Parliament Bill. And they had public meetings and they aroused attention in these matters. But since 1997, the opposition generally has been lamentably weak.
Well, I can't answer that. You have to ask them. We have the Liberal Democrat shadow Lord Chancellor sitting near you, and I think their record has been, if I may say so, in his presence, infinitely better than that of the Conservative opposition, and I simply don't understand why they don't oppose on some of these matters. And therefore I don't expect to see great changes after the next election.
Isn't one of the problems that we have here, and yes, I am a British citizen now, so it isn't one of the problems that we have is that we have a double problem to solve, and one is that we have an unwritten constitution of which it's only really understood by possibly a handful of people. It's not generally understood by the population. I know this for a fact that when I became British, I wanted to be a real true blue Brit. And so I wanted to study what it was to be British. And I called up my good friend who's a solicitor, and I said, since you're going to sign the document that allows me to be British by me taking an oath, what kind of documentation do I need to read? Because in America, you have to learn the Constitution, understand U.S. history. And my solicitor friend said, well, actually, he didn't know that if I actually wasn't born here, I'd find it very difficult to be British. And actually, I have experienced that. I have two daughters. They've been brought up in the educational system here, and they're much more British than I am. No question about it. But isn't not the problem that, one, this Constitution is spread over, I've been told, 7 or 8 different documents. It hasn't been actually brought together, even if it's 7 or 8 documents all together in one document, and that the assumption of the supremacy of Parliament as opposed to Parliament not being supreme, but being in a power-sharing coalition with the judiciary and the executive branch. Isn't this the real problem that we have, is that parliaments, succeeding parliaments, can overturn the conventions that the unwritten Constitution that you're relying on for the Constitution to actually work, being unwritten, it isn't known by that large number of people. So therefore, the succeeding parliaments can pervert it to their own perspective on life. And so I view that as the two ultimate problems that need to be addressed. The fact that we need a written Constitution, and in the Constitution, we then need to demote Parliament and bring up the other two forms of government to be equal. Thank you.
Thank you. Yes, clearly that has become the problem, but one can, I think, attach too much importance to mere words. The real question is whether you're going to transfer power to the judges. And I always used to tease my American friends by saying, well, you have an unwritten Constitution because the document, which I have a copy of, doesn't actually tell you what the American Constitution is. You have to look at the decisions of the Supreme Court, which are often quite remarkably surprising. They distort the words in a way which an English lawyer would find really quite astonishing. So although writing would help on some basic questions, the real question is, are we willing to hand over power to the judiciary who are not elected?
I should just say, abusing my position in the chair in that respect, just echoing that, I think what's very interesting about written constitutions is quite often that in relation to what is often perceived nowadays as the most dangerous branch, executive power, if you look at a whole range of constitutions, which we did in a particular study that I was party to, the actual definitions within those constituent documents were incredibly vague. I mean, forget just how, in addition, you've got the point that John raised about judicial interpretations, which might take it over here, over here, over here. But actually, if you just looked at the wording itself and said, what do you think the executive can do in America or Canada or Germany or Australia, if you just read these words, what do you think the powers that they have are? And you'd be really hard pressed to know, because either they're expressed in very arcane language, or it's very, very brief, or it just is historically outdated in terms of, our conception of what executives do. So, I'm in favour of a written constitution for a whole series of reasons, though I think that it isn't always a panacea. You've just got to construct it very carefully to make sure you hit the right buttons. Yeah. Oh, sorry, the lady at the back has been waiting. Sorry.
The lack of interest or ignorance of constitutional issues that we see today, widespread not only amongst the general public, but also in the main opposition party, in the press, and at the bar, contrasts very strongly with the situation of 100 years ago. The first decade of the 20th century was a time of great constitutional ferment. Just about all the issues that could have been discussed were not only the issue of executive and legislature and the power of the executive and the cabinet, the power of the House of Lords, the party system, federation, home rule. A time of massive constitutional ferment and massive interest in it. In 1905, the British Constitution Association was founded, and Dicey was a leading light in that. But the professors of constitutional law, apart from the letter signed by the Six 3 years ago, seem to have abdicated all interest in spearheading attempts to make these issues important in the way that Dicey would have done. Could you comment on that?
Well, this is why legal historians are trying to help. I think when you're an academic, there is a tendency to cope with all the avalanche of things that are happening, to explain them to your students and to write about them, and perhaps not always to step back and take a public position, which is not easy to do. So I don't want to criticize my colleagues at all, but I certainly felt moved to speak out myself as one of my colleagues who's a public lawyer very charmingly said I was skiing off-piste this evening. No doubt intending that I should be aware of all the avalanches which are to come. But your historical parallel is, of course, very telling. And if you go back to the 17th century, Charles I tries to rule without Parliament, and there's a civil war. And yet here we have a government trying to rule without Parliament, and we're silly to complain about it.
My follow-up question was, do you think that this is caused, perhaps only partly, but by the phenomenon of mass democracy? At a time when far fewer people had the vote, those who did have the vote cared far more about these issues, whereas now, because everyone has the vote, nobody cares. What's everyone's responsibility is no one's responsibility.
Very interesting point. Thank you.
Okay, just I think 2 more questions, and then I think we probably have to wind up.
Okay, thank you very much. I enjoyed your speech very much, and like you, I worry about the Constitution. But take a few issues of your points. Surely, giving Bank of England independence, creating devolved bodies which now have Alex Salmond controlling policy north of the border, having a London mayor which now has Boris Johnson determining so much policy here, having proportional representation for those bodies, same for the European Parliament. Surely you're overstating the worry here. In actual fact, the government, by introducing the Human Rights Act, which allows judges to free prisoners from bail marshes despite the wishes of the ministers, Freedom of Information Act, all of these, actual fact, are the government giving away powers to various other bodies, rather than a power grab, as your suggestion. It also hints what you're saying, that in the past there was halcyon age. Well, I would say the abolition of the GLC, using the House of Lords and backwoodsmen ramming it through, or the fact that Thatcher's only major defeat is on shopping trading, maybe you're overstating your case. Rowley has talked about backbench rebellions, and Bogdaner has also talked about how never so much as the government given away so much power to other bodies, and is a victim of it, even with party funding, has created a bill which has hoisted itself so petard.
Thank you. Yes, I certainly agree that some of the measures have been in the right direction, and I have deliberately emphasised the negative, because I think there's been too little said about these problems that I've mentioned. It hasn't all been good. You read a lot of accounts recently, you would think it had all been a wonderful fairy tale reinvention of constitutional democracy. I just think there's another side to it.
Okay, I think we have time for one more question, and then we have to wind up.
Thanks. Since we have a partly written constitution and a lot of conventions which I don't think are codified, are they? Because I read a tiny little book once which was very amusing. It said the Queen has legal powers as head of the armed forces, head of the prisons, for example, and so on. But of course, by convention, she wouldn't tell the armed forces to go into Iraq or anywhere else, and she wouldn't dream of changing prison officers, would she? So is it codified anywhere, any of all these conventions?
No, that's the essence of the convention, is that it's not codified.
Yes.
Okay. It has been a testimony to the stimulating lecture that we have had a very stimulating set of questions, and we've had an audience which has been invigorated, as it were, by the topic, which is an extremely important one. I think we should just express our sincere thanks to John for a very interesting presentation.